Good morning, good afternoon, and good evening to everyone. Thank you so much for joining us. My name is Molly Steck. I'm General Counsel at STM. And before we get started, and while everybody is still joining up, let me just take care of a little bit of housekeeping. We'll go for about 45 to 60 minutes. I'm going to read out our antitrust and competition provisions first. As far as asking questions, please put them in the Q&A. You'll see a Q&A functionality at the bottom of your screens. And STM member Sarah Fricker, who's head of legal at the Institute of Physics Group and has been just instrumental in this entire work stream, she'll be keeping track of them. And then we plan to address most of them at the end of the conversation. But if something is especially relevant to something that Shan is explaining at the moment, for example, a term that needs defining, Sarah will jump in with that. And I will get started. STM is committed to complying with all applicable competition and antitrust laws. Webinar participants must refrain from disclosing or asking about any competitively sensitive information and shall not solicit any agreement regarding any competitor's conduct in the marketplace. If a panelist or audience member believes any such information or agreement is being disclosed or sought, that individual should promptly interrupt to point out their objections and request that such activity be stopped and leave the webinar, please, if it does not. Thank you. So thank you again for joining us today for this second session in what we're thinking of as an occasional series of webinars that STM is hosting on authors' rights and scholarly publishing. Our first session was back in May 2024, and it brought together two legal experts from publishing houses to talk about how authors' rights in publishing work from the publisher's perspective, like why different licenses are offered to authors and why they might want to choose one license over another. We also discussed how flexibility in licenses help support the sustainability of publishing kind of more generally. And if you haven't seen that, we encourage you to check it out. We'll include it in the notes after this session. In conjunction with that session, STM also released two papers on authors' rights and licensing that you might want to check out as a reference as well, and we'll provide the links to those too. Today's session is a bit different. We are joined by Shan O'Connor, who's professor of law at George Mason University Law School. He's going to help us with this conversation about authors' rights from a researcher's point of view. Professor O'Connor's research and law practice have focused on intellectual property and business law for several years. And just by way of kind of setting out the flow of the discussion, I'm just going to bring just describe three important perspectives that I think Shan brings to this discussion. Firstly, Shan is a scholar and author who supports open scholarship, has published open access, and is someone who understands the importance of finding and accessing others' work. Shan has helped develop the University of Washington's open access policy for its faculty, and he has a lot of practical insights, I think, from that experience. And third, of course, Shan is an IP scholar who understands the ins and outs of copyright law and copyright's goal to promote the progress of science and the useful arts, to quote the US Constitution. So before I get kind of started diving into questions, Shan, is there anything you'd like to add about yourself or to frame the conversation?
I think I would just add that I've had the unique pleasure of being on all sides of the fence of this. As Molly said, I'm obviously a researcher. My primary thing is as a tenured professor, but also at UW, the University of Washington, one of the roles I had was as chair of their IP Management Advisory Committee. And then I was deputized by the Attorney General's Office of Washington State, because when it's a state university, the state's attorneys represent the university because it's a state agency. So in that capacity, I really had to get into the ins and outs of how corporate governance works, how rights actually work. And so I also was in private practice negotiating against universities earlier in my career in tech transfer. And so I think we'll see today that some of the things that I picked up from years of doing Bayh-Dole type tech transfer work are actually going to, I think, be quite helpful as we think about the new regime, especially in the Nelson memo and some of the things going on now.
Thank you, Shan. And just kind of as a way of kind of starting on making sure everybody has the same understanding, especially because we have a lot of foreign participants. The Bayh-Dole Act, which was also known as the Patent and Trademark Law Amendments Act, is a federal law, and it allows universities, businesses, and nonprofits to own and commercialize inventions created through federally funded research. And it was passed in 1980. Okay, with that, and thank you for that useful background, Sean. Let's start with this question. As an academic, can you talk about the benefits and aspirations of open access, what mandates are, how they work, and why academic freedom, among other issues, could be threatened in an effort to implement open access?
And so open access is a fantastic thing for researchers because just wearing my research hat at the moment, it's technology is a mixed bag, but it's great to just sit in your office or in my home office right now, and you have the world at your fingertips, right? So I can find anything, and the more I don't have to worry about paywalls, and all this kind of thing, that's fantastic. Also, as a researcher, a lot of what we really do is not even as much the published work, but I'm often looking to see working papers, what things are out there now, what's on the horizon. Now, then when I go to do the final version of my work, then what I want to do, so notice the flip-flop here. I'm going to start with working papers, what's really on the event horizon, what's the most cutting edge stuff. But then when I reduce my own scholarship to what I want to publish, then I'm going to go and carefully, and then I want to get the version of record. I want to get the fully published thing that came out in my case, law reviews. If you're a science researcher, you're looking at some of the very famous, Nature Science, those kinds of publications. So there's these different things going on. We all want to be able to see what's out there for free as much as possible, but then we need to know that there's a definitive kind of version that we can cite to. So open access can be helpful in that, again, you can find things quite easily. The one that I'll use quite a bit is, well, there's things, it's probably more helpful for science researchers, PubMed, things like that. So that's one of the benefits of open access. Now, mandates are interesting because they started a number of years ago. We'll get more into the details later, I think. But this notion then that we're going to have faculties vote to say that we've all somehow granted a non-exclusive license, it sounds kind of easy enough. Faculty members think it sounds, well, that sounds like a good thing to do. But one of the challenges is once you have that non-exclusive license in place, then it restricts what I can do if I'm negotiating with a publisher, whether I can assign my rights or grant fully exclusive rights. I mean, I can, but it's encumbered by this non-exclusive license. So that can really restrict what's going on. I think a bit later, we'll talk about the fact that this is supposed to be my copyright. My university generally is not trying to take the copyright to my academic research. So one of the threats then to this is as I start having these encumbrances, then I don't really have the ability to choose where, when, how I'll publish my work.
Yeah, and I think you would think of that as I would as an academic freedom issue, in addition to just a burden for an author.
Well, again, the thing about where and when and how I publish is so critical because let's go back to that point I made a moment ago. In the early stages, when it's just working paper level, and I'll put out my tentative ideas, I'm not so worried about that because I can always say, look, I retract that. That wasn't the final version. But it's a very fraught moment for any author, and especially for scientific and academic authors who our entire reputation is based on getting it right. It's a fraught moment to hit that final, I approve to publish this, because once it's published, once it's of record that these are my final great thoughts, if I'm wrong, then I'm going to get hammered on that. So when you look at some of the great old US copyright cases, they discuss things. The Supreme Court says things like this, that the ability to control the timing of when you put your article out there, it can be economically important, but for those of us in the academy, it's more about reputationally important. Once it's out there and it's the version of record, I'm kind of stuck with that. I said that. It's on record.
Absolutely. Thank you. Could you discuss maybe more generally what you see as the best methods for researchers to disseminate their works? You've been talking about uh, various avenues, but it seems that publishers, academics, and funders do have this shared goal of broad dissemination of the most up-to-date research findings, and this is, important common ground that I think we can build on.
Yes, no, absolutely. Again, I think it's really critical is looking at these different stages of the publication process. And for academics, we do need to share our stuff in the early working paper version of it to get early kind of informal vetting from our colleagues. And then we polish it up a bit, starting to get it out there. But then at a certain point, again, we want to get it to a formal publisher. Because if I just put it in a repository, you all know a bunch of them that are out there. Many universities have their own. I can put it out there, but no one's really going to see it. Maybe if it's got a really hot title, people will be, that sounds exciting. But also people are, well, I don't know. Is this really final yet? Has this been vetted? So what publishers play this critical role that they are the imprimatur of quality. So we all are still looking to publish in a reputable publisher because first, that's how we get credit in the academic establishment. And by credit, I mean in the sense of, hey, that person was published in this, they are a real publisher. Look at citation counts for things that academics, they often get, we get evaluated on whether our stuff is getting cited, but not cited to a repository. No one really cares about that. What they care about, did it come through a major publisher and is it being cited to that? So what we're really looking to do then again is get our stuff out early so that we can get thoughts on it and then getting it to a reputable publisher. Now, open access can be the way to go. One of the books we did from the center that I've been leading here at George Mason, Center for Intellectual Property by Innovation Policy, we decided to take a anthology book we were putting together on 5G telecom policy. It was being published by Cambridge University Press, and we went with their open access route. That was fantastic. Now, note that we could have just sort of self-published it or put it on Amazon, but that wasn't where we wanted to go. We wanted this to be a reputable book. So we went with Cambridge, and Cambridge had its standard open access. And that meant that, we have generous funders and things, and we get donations at the center. So we were able to pay for that. And we were quite willing to pay for that because we know the process that it takes to get the reviewers to review the book, to, do the fact checking and all this kind of stuff. So sometimes open access in that formal sense to the publisher can be the way to go. And sometimes you still want to get a book out there that is not going to be open access because honestly, libraries at universities still do want to be stocking these books and they have them. And so you can get access to them through there.
I think another thing that we've talked about before with respect to repositories versus more formal publication is just findability and curation. If you have any further thoughts to that.
Yeah, what's interesting that libraries, now jumping over to the sort of university side and somewhat the governance administrative side, I especially when I was at University of Washington, worked extensively with librarians at the law school and at the university overall. And as we were moving into the digital online world, there were, growing pains. Let's all be honest about that. And suddenly firewalls were going up. It was great. You could get access, sitting at your desk on your computer. But then the publishers had to figure out their business models because suddenly, they now have access through the internet rather than shipping hard copy books. But wait, maybe we still do want hard copy books. And there was weird things like, this sounds tangential, but this is part of the growing pains, was US News, the publication that ranks, schools. You all probably know about those rankings. For law schools, one of the key metrics was how many hard copy books are in your library. So as we started shifting over to digital, suddenly, people were not renewing some of their hard copy holdings, and then they started dropping in the US News ranking. So we all had to live through the past couple of decades in how this transition is working. But I think we have a sense of the models now. And so what we're looking at with the models is that the libraries have limited budgets. But on the other hand, there is still this aspect that not everyone actually wants to read a book online. And so we're finding that, and I include myself in that, that then the libraries still need to have hard copies. So what we're figuring out is how we then get the right pricing models. Libraries, they know they have to spend to acquire these things. It's great then when the students can just go into the library and there's the hard copy on the shelves. Some things it's better and it's easier to have them in database form. So things like the Code of Federal Regulations, US Code, things like that. Maybe you don't need those to be books on the shelves. So again, I think we're getting to a point where the publishing industry and the libraries are figuring out their models, and I think it's all quite doable now.
Thank you. So speaking about repositories, we would understand that depositing content in most of those is voluntary. Would you like to maybe kind of pivot a little and start sharing some insights as to why some universities might want to make that mandatory?
Yes. So this was the part that I had a problem with. And to be clear, when I was helping develop UW's, University of Washington's open access, it was from my role as being chair of the IP Management Advisory Committee. And again, from that, being sort of deputized to be in the general counsel's office for UW. And the central issue we had from the administration side was, how are we going to force faculty members to deposit the copy? I mean, what do we do if they don't deposit? If you're a tenured faculty member, I can't revoke your tenure because you didn't deposit into it. And then what if you're not ready to deposit to it? Or what if you already had an arrangement with a publisher and it was truly exclusive, or you had assigned the whole copyright already? So open access then, and we'll talk about this a little more in a bit, the attempt was to try to get earlier and earlier in the chain. So before you've even written your book, that then you're going to have given this non-exclusive license. But all of this then makes it complicated, because what do you do for the faculty member who has violated this mandate? Furthermore, what happened was that the question of what version, is it the manuscript copy that you had sent to the publisher initially for review to hopefully get accepted? Was it something that was already edited or peer reviewed by the journal? Or was it the finally published version? So the craziest thing I started seeing was, because faculty didn't quite get it, and the libraries and the repositories, the universities didn't quite get it. And so suddenly people were just posting the final, like the PDF that they weren't supposed to be distributing at all, meaning the PDF that came from the publisher of the final version. So all of this, I think, got quite crazy. What the universities need to be getting more serious on now is what exactly they're posting, whether it needs to be mandatory, or whether you simply allow people, as we had been doing before these mandates, to say, yes, I want to then upload this into the repository. Voluntary was working perfectly well.
Thank you. And although I said that we'll take questions at the end, I'll just turn it over to Sarah for a moment in case you've spotted anything that you think we should, bring up now, Sarah.
Yeah, thank you, Molly. Yes, thank you, Sean. There's a couple of questions here which would be worth picking up now. The first one is, what would a perfect OA license look like to you as a researcher or author?
Oh, open access. A system that I thought we had coalesced around maybe 5 or so years ago, which was that, well, let me say two things. One is, if you're looking from the university side, what we should be thinking about for doing open access, and the second would be from the publisher side. On the university, when they're talking to their faculty members, then the faculty member agreeing that then it's a good idea to post the manuscript version. Again, this is before it's been vetted, before anything has happened at the publisher, in a repository. That's incredibly helpful. And again, because a lot of us already do that, because we want to get that early vetting of our work informally. So from the university side, that's really all that needs to happen. Some understanding that it's generally a good idea to post this stuff. Not mandatory, but generally a good idea. Open access, if you're contracted with the publisher, then would be that there has to be the understanding from the faculty member side about what the expenses are that happen from the publisher side to make this, to get it through refereeing, reviewing process, all the production things that have to happen. And so that then the faculty member understands what the costs would be for having open access, and then can weigh out whether they want to then take on, through their grant funders or others, that cost of getting publication done, but still having the imprimatur of that great publisher, or whether they want to go the more traditional conventional route and have the publisher take on those costs, but then have this thing be not open access to the public and just be like the publishing world always was: you pay for the book when it's done. I'm not sure if that's responsive, but I want to make sure those two things are at play.
Yeah, thank you. A couple more questions, if that's okay. The next one is about, again, author experiences and asking for your insight, Sean, on signing Creative Commons type agreements for Gold OA or copyright transfer agreements for subscription publications. And the question is, does the need for copyright transfer in a closed publication scenario actually help to promote open access in any way?
Let me take on the Creative Commons part first. And I'm going to switch a little bit to a little bit of my practice role as well, where from some of the earliest stages in the late 90s, working on open source licensed software. Okay. The challenge with the open source when we're doing the software was that once that's in the chain of development, now it kind of carries with it the whole way. And that can make it hard to do later things with as you want to develop the software further. I know that seems a bit out of whack, but we all have to realize that Creative Commons came about as a way of trying to sort of piggyback onto the open source software movement, if that makes sense to everyone. But just like that potential problem, once you do something like Creative Commons, it does limit what you can do later, only because as you're interfacing with the commercial world, they may say, well, now you've got these licenses, these things out there. And so it's like if I try to sell, I have a house and I have weird rights of way and encumbrances on my property title, then you might scare away some buyers. That's kind of really what it comes down to. And that's what we need more faculty members to understand, that you have to take on these Creative Commons and other open access licenses, knowing what the downstream consequences can be.
Thank you. And the final question for now is that the person asking the question says, don't most institutional repositories and PubMed Central contain the post-peer review version? So the concept of getting your work out early relates more to preprint servers, which is different. And their understanding is that most institutional OA policies, particularly those based on the Harvard one, are still voluntary.
Oh, a couple things baked in there. My experience, it's just my experience, a number of universities, they didn't really, and they still haven't really thought through which version they really were wanted or were supposed to be getting. But the librarians on the ground basically started saying, and then sometimes we're automatically, I found this in my own experience, trying to collect PDFs or scanning in like the final print version of my own articles and posting them. So I had to catch them and say, whoa, wait a minute. I have a different deal with the law review that I published that in. You can't take that final version. So I think it's just been a little chaotic on the ground with the librarians. And then if they pause to think about it at all, I get why their sense is, well, we should get the final published version. But there was no real discussion. The policy making was not that good in deciding at what point in the development from working paper to fully published version of record that this thing was supposed to be grabbed and put into the repository. And let me emphasize that part again. I was finding that libraries were grabbing, once they saw that I said I had published an article, they would then just go out and find it themselves and put it in there without me having said it. I didn't send it to them, nothing like that. So we do have to still resolve some of that chaos that's going on in that way. Now with the Harvard system, what's curious, and we'll get into this a little bit further, I think, what's curious about it is they realized that for faculty approval purposes, they had to allow the so-called opt-out. That, okay, well, it's mandatory for me to deposit and give this license, but I can choose any particular work and say I want to opt it out of that system. But once you have the opt-out, then the whole leverage of what they're banking their system on goes away. The leverage of the Harvard open access system is that, oh, once I've given that non-exclusive license and somehow the faculty vote that happened in the Senate gave that license on my behalf, that's irrevocable. It's irrevocable. And so then that means that when the big bad publisher comes and says, I want all the rights, you have to say, oh, I'd like to give you all the rights, but I can't because I already have this non-exclusive license, this property encumbrance. But if I can opt out, then I opt out. And I do want to get back to this a moment because how that works as a faculty governance matter is very screwy. It doesn't really work the way the open access people think it does.
Thank you, Sean. That's all the questions for now, Molly. So I'll pass back to you.
Thank you, Sarah. Just going back to your immediate last comment, Sean, on the Harvard flavor, I guess, of OA. Could you describe that a bit and when it started and kind of how it's morphed over the years?
Yeah, so the sentiment behind it was interesting. Again, it was if we can get early enough in the chain of when somebody is writing an article, then and ideally even before they've fixed it in a tangible medium, as we'd say in the US under our copyright law. So there's no copyright, there's nothing that even exists. But if I have already before then given a license to anything that I'm going to write to something, the university, it's not clear under Harvard what they really mean by this, given a non-exclusive license to whatever I'm going to write, then that means that that is carries through with anything that I do write later on. So that first part makes sense. And again, the best way to think about it is just a property encumbrance. It's like a right of way or an easement on the property title. Now, also for those of you who are not in the US and in some of the other Commonwealth common law countries, you will maybe be saying to yourself, wait a minute, you can't pre-assign rights like that. And that's a weird flavor of US law that you can, on both the patent side and the copyright side, you can give title to things that don't even exist by contractual agreement. Again, a lot of other Commonwealth countries do not allow that. So you'll be looking at this is crazy. So this system won't really work in those countries. Okay, now, so that's the idea. Let's get this license up front. And then when the publishers come and you want to publish your great work, you have to say, well, it's okay. I can give you a certain amount of rights, publisher, and I can even technically assign you the copyright, but it will carry through this non-exclusive license. And then that non-exclusive license is the thing that allows my school's library to then have some copy, we don't know what version level, but in the repository. Okay, so that was the sentiment behind it. Now, here's the challenge that, again, when I was at University of Washington, we're trying to figure out is the faculty senate doesn't really have rights to bind the faculty in the sense of ownership of property and things like that. Now, a lot of you may have tracked when we had some of the controversies in the US over the past year or so, when the presidents of universities were coming up in front of Congress and being questioned about the Israel, Hamas, Gaza mess going on, then you start hearing about the Harvard Corporation. People said, what's the Harvard Corporation? Well, the thing is, all of these universities in the US, at least, are either state agencies, so that you are part of the state government, or you are a nonprofit corporation. Let's be very clear on that. Faculty senates do not have governance. They do not have legal control over either the state agency version of a university nor a nonprofit corporation. The only thing that has actual control over those is the state government and state appointed authorities or the board of directors of the corporation. Does that make sense to everyone? I don't want to go too far down the weeds in governance, but this is the critical part, is that we working with UW and like the president's office, and we're like, what is the Senate talking about? They don't have the ability to dispose of state property. And somebody make that point very clear. Once you're at a state university, so Washington State, California, you are talking now about somehow the faculty senate saying, we're doing something with state property. It's like saying the faculty senate just voted, we're going to give all the desks away or give all the state's computers away. It's just kind of crazy. So the actual administration of these universities is looking at the Senate saying, well, what do you mean by this vote? I mean, you can all, the people in the room who voted yes, I want to give this non-exclusive license, that vote can be binding on them. But until and unless the actual administration of the university changes the IP policy and puts that in the IP policy, then those faculty senate votes had no effect whatsoever. Now, some of the universities did start then changing their IP policies to start trying to grant this license, but they have to be very careful because writing in things like the opt-out, and then it has to be clear that the arrangement is not between the faculty members and the faculty senate, but the faculty and the actual Harvard Corporation on the private corporation side, or the state of, in my case, back then, the state of Washington. Okay. So, and now keep all that in mind, that machinery, because in a few moments, I think we're going to shift the conversation to talking about how in the Nelson memo and the things going on now, that there's this sense of, okay, somehow in the funding agreement from the federal government to the something, the researcher is going to be bound. And we're going to see in a moment that's not the case, because the contract, a federal funding agreement, and this again is me wearing the tech transfer hat, is between the US federal funding agency and the contractor is the university. Either again, the state of Washington, let's say, or the Harvard Corporation, a nonprofit corporation. It is not a contract between the federal funding agency and Professor O'Connor.
Molly, could I just come in with one question that I think it
Yeah,
might be
please.
raised before we move on, because it a clarification one.
Yeah.
Sean, you mentioned a couple of times books publishing, and the question is what you're saying related to book publishing, if it applies to journals publishing too, and if not, what are the differences between how it applies to books and journals?
Oh, perfect. Yeah, I'm glad you. That's the thing that's always bemused me about this is the way these faculty senate votes have happened. Is it just going to apply to all of your academic writings? So that would include books. So that's again, it's a wild encumbrance to think about the fact that I'm going to have pre-assigned a non-exclusive license to anything I write, whether it's an article or a book. And then exactly, so what happens? Do we then scan in the whole book, or then somehow we demand that, I as the author am going to have to get a PDF of the entire final published book and we're going to post that in the repository? That doesn't make any sense.
I think, Sarah, you've finished your question.
Thank
I
you.
thought I would, thank you. I thought I would raise one that was sent to me directly, which is just more of a request to kind of make concrete the concept of encumbrance that you were talking about, Sean. Like, could you maybe think of a few
Oh,
examples?
sure. Yeah. I'm sorry.
Maybe,
About that.
which also demonstrates, I think,
Yeah.
the salutary effects of having a contract in place.
So when I'm talking about property encumbrances, I mean things like in real property, real estate land. If I go to buy a house, really what I'm primarily buying is not just the structure, but the land on which it sits. Now, it may be that at some point, for whatever reason, contractually or otherwise, the power company that has utility lines or the gas line for natural gas, they wanted to put power lines through this piece of property. And so then what happened was at some point then an encumbrance, an easement or a right of way, those are all somewhat similar concepts, is now on the title. And so that means that when I sell my land later, whoever buys land from me has to understand that the power company has the ability to come on the land in that narrow strip on which the power lines sit, and they can do whatever they want with that. Or sometimes it's just access to a lake. I have property that then, blocks off too much of the beach. And so at some point I allowed an encumbrance or right of way so people can always walk, the public can walk over my property with that. Does that help? That's all I'm talking about when I say encumbrance or easement. Those things carry through. And so if you look at some of the things like the white paper the Authors Alliance is putting out, they are talking about in these exact terms, like, aha, we essentially put this encumbrance on the property to be created, namely the book when I finally write it. And now that's going to carry through for the entire life of the copyright on that book.
Yeah, I think that's very helpful. Thank you. And maybe that's a good segue to kind of this next batch of stuff that I thought we would discuss about, the Harvard type policies, so-called rights retention strategies, and the U.S. Federal purpose license. Could you kind of describe those and whether and how they're similar?
Yeah. So, as I said earlier, I thought we had reached, by we, I mean collectively, kind of the US policy mechanism in universities, a pretty good balance with the publishers that we would encourage authors, academic researchers to post the working paper version, or maybe and when I say final manuscript, I mean final manuscript when I'm ready to submit it to the law review or the science publisher for them to start their review process. Okay. So that seemed to be a good state of affairs, because at that point, if you had received federal funding for your research, most of the ideas were ready in the paper at that point. Does that make sense? So I've got, my tentative conclusions. I've got the ideas. And then after that point, I submit to a publisher, and then it goes through the time-consuming and expensive reviewing process, and then it gets finally accepted or not, and then it goes through all that. The challenge that came was under the so-called Nelson memo, the thing that came out in 2022, is there was, I think, quite an overreach to then suddenly say, no, we want the final published version, and it has to be out there immediately without the embargo, because we also had what I thought was a good compromise of the embargo that was prior to 2022. Okay. Now, let's also be clear on the embargo period. That was not just something that publishers wanted, but in fact, wearing again my administration side, lawyer side for university side, we often try to get our science researchers and engineering researchers to understand that they should be very careful about not releasing their work describing their discoveries and inventions until Patent Council has had a chance to look at it. So universities often lightly embargo the work for their own purposes to make sure we can get the patent on it. Because otherwise, if the science researcher goes to that conference and reveals how the invention works, or they publish it, or even just put it out in a working paper, now in the US, we still have a bit of a grace period, a year to get the patent in, but in other countries, the patent rights are lost entirely. So don't be fooled. The embargo thing was as important to the university and to the researchers if they wanted to get a patent on their discovery as well. So the embargo is a nice thing in place. Now we have in 2022 this notion that's the final published version and it has to come out immediately. But what's fascinating about this is when you look at the Nelson memo, it is guidance only. It is a recommendation. It is not a regulation. It doesn't have the force of law. So this is something I think is being glossed over, especially when you have some folks like an Authors Alliance. I respect what they're trying to do, but they're saying, the agencies have been directed to. If you just look at the language in the Nelson memo, this memorandum provides policy guidance. If you're a denizen of DC, as I, for better or worse, have become, these words mean quite a bit of difference. Provides guidance, okay, to federal agencies with research and development expenditures on updating their policies. In accordance with this memo, OSTP recommends. This is not a rulemaking, okay? So agencies can actually just say, we're not going to do this. Now, I have a sense maybe a lot of them are in fact going to try to do this, but they do not have to. And then the other issue is that as agencies start doing this, people can challenge this as to whether they have overreached their authority. Okay, now let's look at what this thing is leveraged on when you have this bit from the Code of Federal Regulations. And Molly, I think, a lot of your folks may already have these documents, but if we can post them for people later on, it'll be important to have this, the section 200.315 intangible property.
Yeah, I'll
What's
include it in my
fascinating
follow-up.
with this bit is it's kind of been languishing in the US Code of Federal Regulations, and it's not part of Bayh-Dole. It's not part of the regular mechanism for procurement. Instead, it's this, if you look how it's styled, it's like post-federal award requirements, it's guidance. And even though it sounds like, and it says things like the federal government has the right to, this is guidance saying to the federal agencies, ideally, when you fund a contractor like a university to do whatever research project they're going to do, you will put in your funding contract these clauses. If those clauses do not make it into the funding agreement, none of this matters. None of this happens by operation of law. This is the analogy over to Bayh-Dole and the really important Stanford versus Roche case that happened interpreting Bayh-Dole a number of years ago. And again, we can make these materials available. up through the Supreme Court, there was affirmation that what most of us already knew, and I'm going to use sort of a technical legal term at the moment, even by dole is not a vesting statute. What we mean by that is it doesn't, by operation of law, simply by being part of the US Code, determine who owns the patent in the by-dole case. It simply says the Bayh-Dole Act directs the government agencies to put into their funding agreements a default that the contractor, the university, would own the invention, and that then the US government would get certain rights to it, margin rights and a non-exclusive license. That non-exclusive license is the origins of this federal purpose license that now we're seeing imported over to the copyright side. Okay, so the other important thing to understand is that in the US federal system, we have very technical definitions between a contract and a grant and a cooperative research and development agreement. Okay, so contracts, grants, CRADAs are three very different things. Now, what the open access and the Authors Alliance people really want to do is they want to style what's going on in this federal purpose license as if the government is contracting with the university in a procurement sense. And what do I mean by that? Well, the US government frequently, it has to buy desks and computers and commission software to be made, and then that's going to be used by the federal government for its operations. That's a government procurement contract. And then, of course, then the government's going to say, we're only going to buy this stuff from you. We're going to own a lot of the rights to it. Grants are very different. That's to get basic science done. And that's where Bayh-Dole plays its primary role, is that then we're going to say we're giving money to seed to have research done, but then the contractor is going to maintain most of the rights. Okay. It all turns on the funding agreement. There's another part in the Bayh-Dole system that's called Other Transaction Authority, OTA. If the funding agency uses that, they actually get outside of Bayh-Dole entirely. So it's a complex scenario, but the government's always very clear on when they're buying product, and then they're going to get most of the rights, title, and interest to it, or whether they're just funding research that then is supposed to go off into the private commercial world. On the Bayh-Dole side, we know what government purposes means. So don't be fooled when you see some of the stuff, oh, it's wide open. The government has never been in a situation where when it funds basic research in, let's say, military applications, that then it tries to then destroy the private market for those munitions by then saying, well, the government's going to produce it all. So the government does not generally come in. It has not had a history of then destroying entire private markets. Why am I saying this? Because under this, the Nelson memo and the interpretations of it now, it's the sense that, okay, the final published book, the final published article, that'll just be put out for free to the entire world. Well, it's only under a non-exclusive license. Okay, but now you've destroyed the entire market for that. So I don't think this is going to survive any kind of judicial scrutiny. So the more that this is pressed upon to say that means it's just a free-for-all and we're going to put the final published version out there, that's going to be challenged in court, and I don't think that's going to succeed. Okay, so what we really need to be focusing on here is the funding agreements, and then the final part I mentioned, and then I'll turn back to you, Molly. Sorry, I'm going down the rabbit hole a bit here, but is that Authors Alliance has mentioned they're going to do 4 of these white papers. They have left for last, at least in what I'm reading, the most difficult one, which is going to go back to the Stanford v. Roche issue. Part of what went on in Stanford v. Roche is that, as I mentioned earlier again, federal funding agreements between like NIH, for example, and University of Washington or University of California or the Harvard Corporation. The principal investigator, the PI, often signs on as well, but they're not a signatory. They are a third-party beneficiary under standard US contract law. That's the way, and I've done these agreements, that's the way they're written. So here's the interesting rub. It's left to the universities to ensure that they have the rights from the researcher to patented inventions, to copyrights, in the case we're talking about today. That is a really dicey proposition right now because virtually all major universities in the US And we could talk in a moment if we want to go down the rabbit hole of work made for hire, but most of them at least have disclaimed through their policies ownership or authorship of the works that academics create as academics. And so if that's the case, then none of the system really works quite well because the universities can't force their faculty members to do, again, this non-exclusive license or to hand it over entirely. They're going to have to change their policies, and that's going to trigger a lot of animosity from the faculty who will push back hard on that.
Thank you so much, Sean. I mean, yeah, this is just a tour de force of how these things work. And thank you for pointing out the guardrails and, law versus regulations and the mechanics that take place in the background. I think before we get too far down this road, Sarah, I think there may have been a couple questions specifically with respect to OA that you may want to pose.
Yeah, thank you, Molly. There's one question here. It's probably more of a comment, Sean, but just for your thoughts on it, which is that different universities have different OA policies and their understanding. For example, the University of California only applies to scholarly articles and is the author's final version, and covering approximately 50,000 peer-reviewed articles a year. Did you have any comment on the University of California or any other universities' policies that might be slightly different?
Yeah, so California was an interesting situation because they'd originally raced ahead with their faculty senate vote, and then the university had to put the brakes on and say, look, we this isn't actually operable the way you guys think it is. And then I'd actually talked with the folks at Cal when then they did decide as a system and with the different institutions below that overall University of California system to then follow the will of the faculty and to put in these, to adopt as formal university policy, the open access. But I haven't looked at it recently, but my understanding is, as all of the Harvard ones do, there is still the opt-out. And so the opt-out is the one that I think you're going to see possibly even litigation about at some point, because it's not clear how the opt-out works. So in other words, who do I notify? And this is the challenge we had at University of Washington. We were developing ours. You're not notifying the faculty senate about it. You're notifying who? The president's office, the general counsel office of the university. So how the opt-out works and how many people try to affect the opt-out. And then again, the other problem is that if I can do the opt-out, then that means that in fact, this encumbrance, this easement, this right of way can be destroyed by me, the author, by saying, oh no, I'm opting out that book because I want to assign title entirely over to the publisher I want to work with. I'm opting this work out. Does that make sense? So I think that's what we really need to see is when any authors finally decide, oh, wait a minute, I am exercising my opt-out, and therefore then this non-exclusive license is gone.
Thank you, Sean. Sarah, as a kind of co-moderator, would you like to take that privilege and ask any questions of your own?
Yeah, thank you, Molly. Yeah, the one question I had, John, is obviously we can't really have a sort of copyright publishers webinar at the moment without mentioning AI and the risk of content being used in ways that perhaps the authors are, didn't envisage when the articles are posted. And I guess that risk is heightened with repositories. Did you have any sort of experience of that you could share about how universities are dealing with that in relation to protecting content in repositories?
No, I have to say that at the current moment, I've not been working with, say, I've done some stuff with Mason's council, but that was mainly in the pandemic when we were trying to figure out how to put everything online and to do the proper licensing. So I will say that I don't have on the practitioner side experience right now with the AI question. I do very much have what's going on from the researcher side and from the IP angle looking at it. And let me give you a conundrum. Okay, a conundrum that researchers are facing, and that even a lot of what are sometimes called the IP minimalists or IP skeptics who are generally thinking, oh, we should let everyone have access to everything. What's fascinating is that the conundrum is they have a third rail. And we could say in the US, the third rail of politics, and that thing about the electrified rail in a subway system, you touch it and you die because it's such high power. The third rail is claiming ownership of faculty academic works. Okay. But keep in mind again that and that's on the one side, that's sacrosanct. On the other side, to make these OA policies and other things happen in the repositories, we want to then say, well, maybe faculty have given up some of their rights on this. And now what's pushing even harder on this conundrum is AI, because wait, I don't necessarily include me, but the professoriate wants our stuff to be open access in the repository. Everyone can find my stuff because I'm not getting paid for it. So I just want it to be out there for free. But I was like, oh, wait a minute. Now there's these AI learning, data sets, and they're scraping my stuff. And now, wait a minute, they're ripping off all my stuff. Hold on, let's put the brakes on. So you see what I'm saying? So that's the thing I think that universities are going to have to get crisper on, and faculty members are going to have to think through. Is it in fact the best situation where everything is freely out there, easily findable by web crawlers, scrapers, all this kind of stuff? Or in fact, do we want to have some level of control of our work? Because now let's say another thing, look at the defamation cases that are happening already over things like AI is spouting out, Professor O'Connor is actually, convicted of these crimes and things like that. You've probably seen these cases arising already. That's something just talking about my person. But now what if it says Professor O'Connor said in 1990, whatever, and it says something wildly opposite to anything I put in any of my articles? That can easily come out the back end of generative AI, right? Because it just spews together words. So we're going to see this challenge now that faculty are going to start saying, wait, not so fast. I want to control. Maybe we shouldn't have the stuff as freely available. It's got to be firewalled somehow so that then it just can't be grabbed by every large language model. So I think, again, this conundrum is what's going to be a golden opportunity, I think, for the publishing community to help guide policymaking and help guide the thinking of faculty members that scientific publishing has like 400 or 500 years of history at this point in how to usefully get stuff out so that it's high quality, reputable, you can trust it. And then how do we get that out to the world? So I think that's the touchstone we have to come back to. Hey, there happens to be a system, scientific publishing, that's been really good for hundreds of years in trying to get the version of record out there. Let's talk about this before we get more misinformation and disinformation and things about Professor O'Connor said X, Y, and Z, which I never said in my life, but now that's what's being spewed out of an AI model.
Thank you so much. I mean, yeah, research integrity and the integrity of the scientific record is so paramount to us. Sarah, I'm going to ask you to do a difficult job and just pick one of the final questions, and then I have one, and then we'll be at the hour.
Yeah, thank you, Molly. I mean, there's three more questions left in there, so I'm just going to pick out the one that just because it follows on from what you were just talking about, Sean, and AI, which is how do authors go about gaining control of their work if licenses that take AI into consideration might not exist yet, and what support is there for faculty to help them navigate this?
Good. The challenge we'll be seeing on the ground is the post-Tasini world. And let me explain what I mean by that. Tasini, Tasini, the lawyers, well, many of you lawyers, you'll know what this means, but it was a big US case. And it was all about this question of, as we're moving into new digital media, did a lot of the old existing print world licenses or assignments from authors cover these new technologies? Okay. So post-Tasini, council started from the publisher side, started trying to write clauses that, in any medium hereafter to come about, to try to capture all the new types of things that would happen. So one question right now and this is between the publishing community and the generative AI world, is that do in fact the publishers have the rights to license to an AI company? Here's all these writings of these authors that we have signed, or do the publishers' agreements with the authors not cover that? So that's one question. That's something for you all to sort out with your own existing agreements. But now the authors are starting to ask that question themselves. Oh, wait, let me look at my publishing agreement, doesn't in fact cover and allow the publisher to have my stuff put into a data set. And so this, again, is what I'm saying, is it's a good time of reckoning and reflection to start thinking about how publishers have amazing common ground with authors now, because we all want to protect, us as academics and publishers want to protect the integrity of the system. This is the time to revisit some of these agreements and start thinking about how the rights are going to play out. I know that with at least, I won't name the press, but one of the major academic publishers, in one of the publishing agreements I had, they did have to send out a supplement asking whether we and the contributors of the book would all sign on to allowing it to be licensed out for AI. And the challenge, so that press decided that it did not yet have those rights. So this has to be thought through quite carefully. And so I don't know which way it should go, other than I think that people should be very intentional about whether these rights have been granted or not.
Thank you, Shan. Thank you, Sarah. I'm just going to end with one final question, and it's quite open-ended, and I think what you've just ended on is actually very useful, Shan. But if you could sum up, like what effects do you think these mandates and requirements regarding access and licensing have on researchers' opportunities to be published and get their work read? Is there just kind of a final upshot you'd like to impart?
Yeah. This may be one of those situations where, think about the old children's game of tug of war, and you're pulling on the string and you're pulling really hard and the opposing team is pulling hard in the other direction. And then suddenly the other part drops the rope and you go flying backwards. I think that very soon the academics are going to realize that they are now flying backwards, and all this stuff that they were told that they should want by some of these organizations like Author Alliance and whatnot is not really what they want. And now they're going to find that, oh, this full speed forward of trying to put these mandates in and non-exclusive licenses that then, and then we're just going to, the librarians are going to grab your stuff and post it in this open repository. It all sounded grand. And then we're going to realize we're all caught off balance and we're in a very bad situation. And we need to quickly pivot and think about how we want to reassert control in a world of disinformation and quite dangerous disinformation. You're a climate scientist and you don't want your stuff being quoted as saying something 180 degrees different from what you're saying. So we do need to galvanize the academic community to reassert some level of control and realize that firewalls and things can sometimes be good, can often be good. And we can work, the publishers have done a fabulous job of creating open access models. And then you have to share the costs. And then the federal funding agencies have gotten more comfortable with allowing that to be in the grant. And so you can still have stuff that is available enough, but we want it to be that there are some guardrails and protections so that it's not just grabbed willy-nilly by AI and spouted out in disinformation that's quite dangerous to the world.
100% agree. Thank you so much, Sean. Every time I talk to you in whatever format, I learn so much. So thank you again for joining us. I would ask everyone to join me in a round of virtual applause.
Thanks
Thank
for the
you so
opportunity
much.
here. I appreciate it.
Take care. Bye-bye.